All right, going to call us to order. We are reconvening. Let's see. First on the list, again, it is, we're going to do Representative Freiberg. All right. So I will move to recommend that House File 1459 be re-referred to the Commerce, Finance, and Policy Committee. I understand there's a DE1, so I will move the DE1 to get the bill in the shape the author would like. All those in favor of the DE1, please say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Representative Freiberg, please tell us about your bill as amended.
Thank you, Chair Becker-Finn, members of the committee. This bill seeks to restore the right of Minnesotans to obtain compensation and justice for consumer frauds committed against them by unscrupulous operators in violation of our Consumer Fraud Act. That right was taken away by the courts in 2000. This bill would give it back. Public enforcement of our consumer fraud laws holds the perpetrator accountable but does not make the victim whole. Recognizing that unfairness, the Minnesota legislature passed what has come to be known as the Private Attorney General statute. That was passed in 1973. That law provided that a regular person who was hoodwinked in violation of our law could take a court action to seek restitution just for themselves. Attorney fees were included because they can be as much or more than the compensation the consumer receives. This was kind of a sleepy little law that did just as it was intended for 27 years. And during that time, to my knowledge, the law was undisturbed. There were no attempts to repeal or modify it, and no one alleged there were any problems whatsoever with its intent or with its implementation. It gave the individual who was victimized by fraud the legal tools to redress the wrongs committed against them, whether those wrongs were committed by a shady timeshare seller, a prize solicitation flim-flammer, a home improvement scammer, a service contract huckster, a dishonest solar panel peddler, or a loan mod con artist. In 2000, the courts effectively closed the courthouse door to justice for fraud victims. In a case called Lee versus Nystrom, the court held that not only do you have to show you were defrauded, but you also have to show that what happened to you has happened to many others, and by proving fraud and getting your money back will also provide a public benefit. That has proven to be an insurmountable hurdle for individual consumers since 2000. This court-imposed test, how are you doing? Good. Good, which has no basis in the plain language of the statute, turned the statute on its head. The law was intended to facilitate, not eliminate, the rights of consumers to obtain relief from fraud and deception. The E amendment that you just adopted does two things. First, it restores the individual's right to redress they had for 27 years prior to the court effectively taking that right away. And second, it overturns the Lee versus Nystrom case with regard to the Consumer Fraud Act. We've been in conversations with stakeholders about this bill, and those some of the concerns that have been raised are reflected in the DE amendment that you adopted. And to that point, I would like to thank these stakeholders, including the Insurance Federation of Minnesota, the National Federation of Independent Business, and the Minnesota Realtors for their engagement on the bill. I know they still have some concerns, and we will continue to listen. But with that, I'd like to turn it over to my testifier, University of Minnesota Law Professor Prentice Cox.
All right, please introduce yourself for the record and then proceed with your testimony.
My name is Prentice Cox. I'm a professor of law at the University of Minnesota Law School for the last 17 years. Before that, I was an assistant attorney general in charge of the consumer division at the Minnesota Attorney General's office. Thank you, Madam Chair, Representative Freiberg. You said most of the things I was going to say, so I'll cut it in half. Nobody minds hearing that. Just the language at issue that was interpreted in 2000 really couldn't be much more clear. The section 8.31 subdivision 3A, the Private Attorney General statute, the key phrase is any person injured by a violation of the laws referred to in subdivision 1 may bring a civil action and recover damages. Right? That's the key phrase. It's absolutely unambiguous. For whatever reason, in 2000, the Minnesota Supreme Court interpreted that to essentially add a phrase on to say may not bring such an action unless it's in the public benefit, which was interpreted as more than a one-on-one transaction, although it's quite ambiguous and the courts have a hard time figuring out exactly what it means. But what we know it means is that after 2000, individual consumers, including family farmers and small solo practitioners, have had a very difficult time bringing any suit. It's very difficult to bring a lawsuit if you're an individual, if you're a family farmer, under this test that says that if it's just a one-on-one transaction, you can't sue under the Consumer Fraud Act, despite the clarity and the unambiguous nature of this language. Interestingly, cases brought by business plaintiffs fare much better because they tend to be suing about advertising or broader broadcast sort of misrepresentations, and class actions are not generally a problem with the public benefit test. So what we've done is we've turned the consumer fraud, this ruling has turned the Consumer Fraud Act into a law that can be used by business plaintiffs and class actions fairly regularly, but average people can have a very difficult time using the act. Important to note that all 50 states have a private right of action for consumer fraud, and only 6 other states have a public benefit restriction. In 3 states, the courts did what our courts did, which was write into the law a public benefit restriction, and their legislatures overturned it, as you're being asked to do today. Those states are Illinois, Connecticut, and Hawaii. So we're not plowing new ground here. We're just simply trying to restore the status quo prior to this decision. A review of all 50 state consumer fraud laws by the National Consumer Law Center led to that organization calling Minnesota's consumer fraud laws weak, and that the public benefit restriction, quote, makes it extremely difficult for consumers to bring suit under the statute. This law would just bring Minnesota back into the mainstream of other states and back to where the law was in 2000. The last point I would make is that one of the oddities, in addition to the clarity of the language at issue when it was interpreted in 2000, was it wasn't entirely clear why what the underlying concern was, given that there really hadn't been any cases that had posed a problem or that anyone would call an egregious misuse of the statute. In fact, in the case itself, Lee v. Nystrom, there was a majority and a dissent. The dissent by Justice Page and a dissent by Justice Gilbert, who was appointed to the court by Governor Carlson. And in the majority opinion, in the 5-person majority opinion, even the majority opinion called the defendant's conduct in that case reprehensible. So it's not, this was a restriction in search of a problem, and it's been a generation, and it's time to restore it to where it was prior to the date of that decision.
All right, thank you for your testimony. Next up, I have Jennifer Bredinger. I apologize if I did not pronounce your name correctly. Please introduce yourself for the committee and proceed with your testimony.
Thank you, Chair Becker, Finn, and members, and pardon my voice this evening. I'm not sure what's going on. My name for the record is Jennifer Bredinger, and tonight I appear before you on behalf of MinFLOR, it's Minnesotans for Lawsuit Reform, to speak briefly on House File 1459. It is a bill that would allow individual lawsuits claiming a violation of our state's Consumer Fraud Act. We do appreciate the fact that the amendment narrows the bill from that which was originally introduced, and we have been working, I would say, playing very well with Ron Elwood. We really appreciate him being open. We have had several meetings, and I hope those meetings continue, and we'll thank the author too. The bill before you, however, as the previous testifier spoke to, would overturn 2 decades of legal jurisprudence. So both in Lee versus Nystrom, it was a case where there actually were other remedies. It was essentially, unfortunately for the plaintiff, a bad business decision. There was fraud, but we believe that even in that case, there were other common law elements of tort and contract and fraud that could have been alleged and were in fact alleged. The courts do not want to have business decisions come before them. They don't want the private attorney general statute used for those kinds of situations. But you're asked now, tonight, before you to overturn 2 decades of legal precedents. So we are not aware of what problems we're trying to fix. And we have asked what specific problems and cases where there has been a bar trying to use the private attorney general statute. Some of us remember the serial litigation years ago with Paul Hansmeier on the Americans with Disabilities Act cases that preyed on small businesses for 5 years until he was stopped and ultimately disbarred. So MnFLR would like to see a couple clarifications under House File 1459. A plaintiff should have suffered actual harm, direct or indirect, we'll take both, before bringing an action. Without such language, we contend a plaintiff could actually sue under 325 with no public benefit, no damages, and still be permitted to collect attorney's fees. And although people will say you need causation, you need standing, and of course you do, a case only 1 year after Nystrom, which was the Group Health versus Philip Morris case, had facts such as no direct harm was alleged or proven or needed, nor reliance, nor was there found to be any for the plaintiff individually. They were suing on behalf of their insureds or enrollees. So just a couple more concerns, and I'll be quick. With regard and concern to access to justice, a provision permitting the court to award attorney's fees, costs of investigation, court costs, where it determines that an award would eliminate financial barriers would be something we'd be interested in seeing. And again, serve justice just as well as maybe overturning the test that's been around for a couple decades. Also, that the challenged practice, what's alleged in the case, would impact other consumers or had the potential to impact other consumers in the future. With that, Madam Chair.
All right, thank you for your testimony. Are there any other members of the public wishing to testify on this bill? All right, seeing none, we'll move on to member discussion. Representative Niska.
Thank you, Madam Chair. And Representative Freiberg, I just want to be totally clear on the record about what we're doing. We're not amending 8.31 the way that the bill has been amended. We're just amending the consumer fraud statutes to add in a private right of action provision that sort of mirrors what we have in the private attorney general statute, but without the Lee versus Nystrom test. Is that an accurate summary of what the bill as amended is doing?
Representative Freiberg.
Yes, I believe that's accurate. Yeah, I'm getting nodding. So there's no, under the delete all amendment, it just amends section 325F, which is the consumer fraud statutes. There's no reference to section 8.31.
House Research is nodding, so.
Okay.
We've answered the question. Follow up, Representative Niska.
Yeah. Thank you, Madam Chair. I just wanted to make sure that was clear for the record because there was discussion about the Lee versus Nystrom test in conjunction with 8.31, and we're no longer actually touching that with the way that the bill has been amended. I just wanted to make sure that that was completely clear for the legislative record. But I also did want to ask Representative Freiberg about the meaning of the term injured in this statute, and I do share the concern from Ms. Breitinger about, and I have actually handled some of these disability shakedown kind of cases where there's really a manufactured injury that's used to then back into private right of action with an attorney's fees provision, and as a legislature we had to go back and try to fix that after the fact. And so I just want to make sure that we're not, that we're thinking about injury in a way that isn't going to trip into those same problems with the, in 325F, the consumer fraud statute. So I'd love to hear what injury means in this, in the context of this.
Representative Freiberg.
Thank you, Representative Niska. Thank you, Chair Becker-Finn. Yeah, I'm glad you brought up, Representative Niska, the drive-by lawsuit example. In my mind, that's kind of like comparing apples and oranges. That example does not involve the consumer fraud statute, which is all this bill would touch on. The fraud statute is very fact-specific. It's not something you can use for, drive-by lawsuits, I think is the term that's thrown around in reference to that example. Like, there's no, you can't, see a fraud happening on, just by driving by it. So, the word injury is, just to your other question, the word injury is currently used in 8.31. It was clearly understood for over 2 decades before the Lee versus Nystrom case, but it looks like Professor Cox might want to comment on this as well.
Professor Cox to the question.
Madam Chair, Representative, I was the lead attorney of the last case to in 2019 for the Minnesota Supreme Court to interpret that actual term, injury. So I think there's a set of law around that. It's common to several other states, many other states that use the term injury as well. And the court has clearly defined, in this 2019 lawsuit, Engstrom versus White Birch, which was ultimately dismissed on the public benefit test after remand. He was a son of someone who had bought a timeshare, and the timeshare company decided that he was a part owner, even though he had never received a deed, he had never received a bill or anything. And then they threatened to collect fees from him, threatened to send him to collection if he didn't sign a quitclaim deed or pay the fees that were owed on the timeshare. So the suit was brought under those alleged facts, and the court held that having to go to an attorney, for instance, when you've been threatened with this, he denied that his mother had ever signed this over to him. And there was a question of the notary being invalid and lots of problems. And the court held that, this is an example, that when having to go to an attorney, having to pay money to that attorney to advise him about what this deed was that he claimed was false, constitutes injury. And the court looked at that and overturned the Court of Appeals on that issue, and in the process, I think, set out what they thought the law was regarding the meaning of that term. So I think that case, fairly recent case, sets the law fairly clearly.
Follow-up, Representative Niska.
Thank you, Madam Chair. And Professor Cox, I'm not sure that I really heard an explanation of what that test is. Can you kind of lay out for the record, what is the requirement? Is there some sort of concreteness requirement, or in the federal context, obviously for standing, there's an injury in fact requirement that's particularized and concrete. Is that something analogous to that in the Minnesota context, or can you just help us understand what the injury requirement is going to be under this law?
Professor Cox, as succinctly as possible, please.
Madam Chair, Representative, that, of course, is the Article 3 standing test, which doesn't apply in our state courts. Injury was defined in that case as having to pay, because he had to pay money and he had to consult an attorney. It's like most areas of law, there's going to be some, ambiguity on a term like that. However, you just can't file a lawsuit and say, I don't like that advertisement. You have to establish that the falsity of the act or the conduct injured you in order to have the capacity to bring a lawsuit.
Final follow-up, Representative
Yeah, thank you, Madam Chair. I just wanted to say that I think it's possible that a court interpreting this law down the road might be listening to this hearing, and I just wanted to help kind of provide some context and clarity to that, so thank you.
All right. Any further discussion to the bill? All right. Seeing none, closing comments, Representative Freiberg.
Thank you, Madam Chair. Thank you, members of the committee. Thank you, Representative Niska, for the questions. One of the testifiers asked what problem this is trying to solve. It's basically the inability to use the consumer fraud statute. We are unique among states in having this public benefit test, well, almost unique, and not in a good way. The Lee versus Nystrom case created an extra statutory requirement that you have to, in addition to proving that you're a victim of a violation of a consumer protection law, you have to show that your case was of a public benefit, and no individual has been able to move forward because that test has been insurmountable. That case from the Supreme Court turned the original intent of the statute on its head, and I think when that happens, we as legislators have a responsibility to fix that. This is a statute that was intended to provide, not eliminate the opportunity of an aggrieved consumer to get restitution and other relief from a violation of the consumer protection laws. Encourage the time you put into discussing this bill, and would encourage members to vote yes on it.
All right. I will renew my motion to recommend that House File 1459, as amended, be re-referred to the Commerce, Finance, and Policy Committee. All those in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. Thank you, Representative Freiberg. Next up, Representative Finke. Representative Finke, would you like to move to recommend that House File 1655 be placed on the general register?
I would.
All right, we've got the bill in front of us. I see you've got an A2 amendment. Would you like to move the A2 amendment and then tell us what it does?
Yes, I would, Chair. Would I be able to adopt the amendment and then explain the bill as a whole, or do we need to do the amendment
If it's
separate?
easier to do it that way, I think that's
I
fine.
think it would be.
Okay. All those in favor of the A2 amendment, please say aye.
Aye.
Opposed?
No.
The motion prevails. The amendment is adopted. Representative Finke, to your bill as amended.
Thank you, Chair and members. This is the Take Pride Act. It is a bill that does two things. It modernizes our Human Rights Act in a number of ways, bringing it into a more contemporary understanding of what this is trying to do, and I have Commissioner Lucero here who will explain that. It also creates a definition for gender identity and adds gender identity into the list of protected groups under the Minnesota Human Rights Act. It's important that we continue to evolve our laws as our understanding of what it means to be a full and authentic human is. We do this throughout history, throughout time, and this is a great moment for us to expand what it means to be a person and to protect all of us. So that's what my bill does, and I hope we can have your support.
All right. Commissioner Lucero, please introduce yourself and proceed with your testimony.
All right. Hello, everyone. Chair Becker-Finn, committee members, it's good to see you this evening. As you know, my name is Rebecca Lucero, and I'm the Commissioner for the Minnesota Department of Human Rights. Thank you, Representative Finke, for carrying this agenda policy bill, and to the committee for hearing this bill tonight. So House File 1655 is the Take Pride Act. It's a bill that's been long overdue. And so just going to take us back real quick to 30 years ago, 1993, if you can remember where you were in 1993. That was when state legislators here at the Capitol came together across party lines to make Minnesota the first state in the country to prohibit sexual orientation and gender identity discrimination. So think about what the world looked like 30 years ago and how much the legislature and courts have updated and clarified the law. So a few examples: the state of Minnesota legalized same-sex marriage. That was August of 2013. In 2015, the U.S. Supreme Court ruled in Obergefell, that there is a constitutional right for marriage between same-sex couples under the Constitution. And in 2020, the U.S. Supreme Court Bostock decision held that an employer who fires an individual because they are LGBTQ is in violation of Title VII of the Civil Rights Act, matching what has already been in the law in Minnesota since 1993. So it's time to update and clarify the Minnesota Human Rights Act to bring it into 2023. So the Take Pride Act does four more wonky things that I'll go over. First, the Take Pride Act removes outdated language that says Minnesota does not condone homosexuality and does not recognize the right of same-sex marriage. So why should this language be removed? Well, because Minnesota does recognize marriage between same-sex couples. Why should this language be removed? Because Minnesota does not object to someone based on their sexual orientation. The second provision provides a definition for gender identity so that gender identity, which has been a protected class since 1993, has an updated and clarified definition. And I'm loath to ever
Please correct me.
Okay, and if that's okay, I really want to say this is not expanding. Sorry.
No?
This is not expanding anything. This has been the law since 1993 in Minnesota. Gender identity has been the law as a protected class status along with sexual orientation under the Minnesota Human Rights Act since 1993. So this is about clarifying and updating what has already been the law, making it more in alignment with where we are right now.
Correct me.
The third piece here removes the provision that allows for discrimination based on sexual orientation to occur in a duplex. So let's look at what the law currently is about someone who owns their own home. In that situation, nothing changes under the Take Pride Act. And so I just want to make sure you see the statute holistically. So when it comes to your own home, this bill does not change the fact that you get to select who lives in your own home. This bill removes no restrictions of the use of one's own home. You can find those restrictions under Minnesota Statute 363 8.21, subdivision 1, paragraph 2, those remain fully in place. So again, when it comes to your own home, nothing changes. What else the law currently says? It says that if someone owns their own 400-unit apartment complex, a 40-unit apartment complex, or a 4-unit building, and they live in that building, they want to rent out the other units, they can do so, but just like any coffee shop or grocery store, they cannot deny someone's business because of a protected class status. That means a landlord cannot deny someone housing because they have a kid, because they are of a certain race, religion, or because they are gay or straight. That is the law right now. So the only change here is to align with what the law currently is to all rental units so that duplexes are treated the same as any other rental unit. The fourth provision ensures that all nonprofits follow non-discriminatory law. When I talk about this provision, I oftentimes get asked questions like, wait a minute, I understand tax law and religious organizations are also 501c3s. And so is that what you're talking about right here? And I just want to answer that for religious organizations, which of course are 501c3s, that have a religious belief that is incongruent around sexual orientation with their religion, there is an exception in the Minnesota Human Rights Act. You can see that laid out in MnStat 363A 20 subdivision 2. That stays the same. That allows for religious organizations to actually exclude, keep somebody, that allows for religious organizations to place restrictions on someone because of either their religion. You maybe want to make sure that it's kept to a certain religious group or because of sexual orientation. That exemption remains fully in place. So nonprofits that are religious in nature, where their religious beliefs are incongruent with someone else's sexual orientation, they can continue to place restrictions based on religion or sexual orientation as laid out in statute. So in closing, I just want to highlight that there's several really important stakeholders that have come out in support of this, from the religious communities to nonprofit organizations to youth groups who all understand the importance of updating our statute to provide that clarity from where we are today. So thank you for the opportunity to testify.
Representative Finke.
I just want to take a moment, thank you, Chair, to thank the Commissioner for correcting me, because Minnesota is a leader. Minnesota was the first state in the country to protect gender identity. So I was referring to the updated definition and the expansion of how we understand gender identity, what it means to have a new definition in a new decade. But it's very important that we recognize that we were at the forefront of doing this work, protecting trans people, protecting gender expansive people. And so I'm grateful to have the record corrected.
Thank you. Any other members of the public wishing to testify on this bill? All right, seeing none, we'll move on to member discussion. All right. Closing comments, Representative Finke.
I just want to thank Chair and the members, the Commissioner for coming down tonight, and I hope everyone supports this bill. It's good work.
All right, thank you. With that, Representative Finke renews her motion to recommend that House File 1655 as amended be placed on the general register. All those in favor, please say aye. Aye. Opposed? No. The motion prevails. Next on the list, Representative Moller. Representative Moller, I will move the bill in front of us. My understanding is the plan is to lay this bill over. I'm getting nods. So, all right, I will move the bill, House File 226, in front of the committee. Representative Moller, please go ahead and tell us about your bill.
Thank you, Madam Chair and members. So some of you have heard this bill in public safety this year, or if you were here last year, we've also heard this bill in I don't know if it's last year or a couple years ago, sessions. But House File 226 is a bill that allows for prosecutor-initiated resentencing. For some people who have been sentenced in the past, their sentence may no longer serve public safety or the interest of justice and may waste resources. Prosecutor-initiated resentencing establishes a process for which prosecutors can initiate court review of lengthy sentences with participation and input from victims. It's entirely discretionary for the prosecutor to do this. Currently in Minnesota, after someone is sentenced, and that sentence, let's say it's appealed, it's upheld on appeal, there is no way to later have that sentence changed, even if everyone agrees that incarceration for a particular person is no longer needed. And examples of such situations where this is envisioned to be used, and where it has been used in other states, are elderly prisoners who no longer serve a public safety risk, people who've gone through treatment and been rehabilitated, and whose caseworkers say they're complying with all the requirements. Victims are given multiple opportunities to provide input, and you do have a support letter in your packet from MNCASA and Violence Free Minnesota, victim rights organizations. And then courts, in addition to just this agreement, the court must actually make a determination and find substantial and compelling reasons exist to adjust the sentence and must consider the impacts on public safety. I do have a testifier here, and I'm glad to answer any questions.
All right, I have Tammy McConkey. Please introduce yourself for the record and proceed with your testimony.
Thank you, Chair Becker-Finn and Representative Moller. My name is Tammy McConkey, and I've been a prosecutor for a little over 28 years in the Ramsey County Attorney's Office. During the last 10 years, I've been a division director, and my division has 2 units in it. One is a unit of crime victim advocates who help crime victims through the system once we've charged a case and make sure that their statutory rights under Minnesota Statute 611A are realized. The other unit is a unit of attorneys who handle sentencing hearings and other post-conviction type hearings such as expungements. As we do our work, we do become aware of cases where the situation has changed since the time of sentencing. It's not so much that there's something wrong with the sentence, but we have different information and maybe different science that we now understand better, such as the development of the human brain, where we now know that a brain is not fully developed until someone is 25 years old. And if we think back to times when we convicted certified juveniles when they were 15, we realized that those kids were a full decade away from having a fully developed brain. Sometimes what we know is that what's changed is the person that we've convicted, and we receive information that they've done work to rehabilitate themselves and have really become a different person. And so in those circumstances, when somebody has rehabilitated, when they've already served a large chunk of their sentence, the question for us then becomes, is there any purpose for them that serves justice to complete the rest of the sentence? And so this bill, right now under the law, as long as the original sentence was legal, there is no path. This bill would give us that tool and would allow us to really take a careful look at these cases, spend time with victims, talk with them about it, and then if we deem it appropriate to go ahead and file a petition to adjust a sentence for someone. So thank you.
All right, thank you. Any other members of the public wishing to testify on this bill? Great, not seeing any. We will go to, we do have an amendment that's been filed, the A3 amendment. I believe that's Representative Johnson. Representative Johnson, would you like to move the A3 and then tell us what the amendment does?
Yes, I'd like to move the A3, and what the A3 is there's three different things to this amendment. First of all, it sets up that if there was unfortunately, it wasn't worded correctly, so that isn't quite right. But if there's basically a plea agreement done, then they would not qualify for this because the negotiated of the sentence has already been done. The second part is, and that's a two-part of it, is the hearing should take place before the judge who did the initial sentencing or in that seat if that judge has retired or no longer there, because that's where the reports are and that's where the prosecution originally occurred. That's where everything is there. And the third part is the judge or the pre-sentence investigation, if there was one, that should be available, and that's the pre-sentence investigation report should be the one used. I want to thank Representative Moller. It's getting late. We've had a good conversation. We got some issues to work out, And we agree on some things, we disagree on the others, but we're working our way through it. And so I'm going to withdraw the amendment, but like I say, I do think it's a good thing that if we can, handle it by the judge as much as possible that handle the case, because he understands the facts of the case.
Representative Moller, who I know there's maybe nobody better at making sure that she's talking to everybody and trying to work with folks. Representative Moller.
Yeah, thank you, Madam Chair, and thanks for that, Representative Johnson. There are things, like you said, I agree with, and things that I don't disagree, or that I disagree with this amendment. I think the part about the plea is a problem for me, because really the idea of this bill is for people who are rehabilitated to be able to apply. Usually someone that pleads guilty and admits their wrongdoing right up front might be someone who later on is going to go through treatment and comply with everything required. So I don't think the fact that, it was a plea would necessarily be, should be part of this process. But I will say, and for your second part of the amendment regarding the same judge, I'm not sure with separation of powers we can say which judge, but I think we can certainly clarify that it has to be filed in the district court where the conviction was had, and how they end up assigning judges. I know when I do post-conviction, typically they do try to assign those same judges, but they may have moved to a totally different area. And then the third part of it, I think it's a good idea, actually, to have them reviewing those pre-sentence investigations. So that's something I would like to incorporate into this bill.
Further discussion to the bill. Representative Scott.
Thank you, Madam Chair. And Representative Moller, I had a conversation with you on the floor yesterday about every time there's a reference to victim in this bill, and whether or not, if the victim is no longer able to speak for his or herself, if that could be added to the statute or to this bill. And so I think you were going to check out another area of statute and let me know if that would always include the victim's family member if the victim was unable to speak for themselves.
Representative Moller.
Thank you. Thank you, Madam Chair. So yes, 611A, I know when prosecutors talk about victims, a lot of times we're thinking about Chapter 611A, because that definition of victims includes when there's a deceased victim, family members, and it's a pretty broad definition, and my testifier is an expert in victim services, so we can have her give you the exact statute number. I actually think it wouldn't hurt also when we amend this bill to add in a reference to maybe the first time we reference victim as defined in 611A, I think it's .01, but perhaps my testifier can. Yeah.
I think that's right.
Director McConkey.
Representative Moller, I believe that 611A.01 is the correct site, and it does include family members, but I'd like to confirm the number. I'm not positive.
And we can get that confirmed. That's one of the reasons we're laying it over, so we can make sure we get this right. Representative Scott.
Thank you, Madam Chair. And I'd also like to know if that includes not just if the family member or if the victim is deceased, but if they're a minor child or something like that, unable to speak for themselves. If they've been the victim, if it would also include that. Maybe, I don't know if you know the answer to that, or Mr. Johnson, maybe.
Mr. Johnson.
Madam Chair, members, I can read it. It is 611A01, paragraph B. It says, victim means a natural person who incurs loss or harm as a result of a crime, including a good faith effort to prevent a crime, and for purposes of, and then it references some sections, it also includes a corporation, a government entity, and any other entity authorized to receive restitution. And it goes on to say the term victim includes the family members, guardian, conservator, or custodian of a minor, incompetent, incapacitated, or deceased person. Goes on from there, but I think that's the section you needed.
Representative Scott.
Thank you, Madam Chair. Thank you for that. And I'm glad that it covers those folks, but I still do have concerns that this is dredging up a traumatic experience for the victims again, and they're having to go through all of those feelings and redredging the experience. And I think it's unfair to the victim to do this. While you might find it fair to someone that you believe is rehabilitated, I just, and I know you have the Minkasa letter, whatever, but I feel like it's just not fair to the victim. And I also know that, we've had the courts in here and they've testified to the backlog of cases that they have. And it just seems like our prosecutors' time would be better spent getting the bad people off the street rather than going back to someone that has been sentenced, had their day in court, rather than having the prosecutor spend their time on, and kind of like going from the prosecutor to now the public defender, where you're defending the fact that they should now be released. I just have real concerns with this and what it's trying to do. I believe in second chances, but at the same time, I don't know. Just really conflicted, I guess, with this bill. And so I'm glad it's being laid over. Gives us more time to talk about it, think about it. Thank you.
Representative Johnson.
Chair Becker-Finn, Representative Moller, I understand the concept that you're looking at here. And like Representative Scott, I have concerns about the victims in these, especially with some of the violent crimes. My wife was a victim of burglary, and to this day, I still get locked out of my house if I go outside without the key. That's why I now have push-button locks on the door so I can actually get back in if I don't have my keys with me. And that was when she was a child. Being a victim of a crime, and some people, it lives in them forever. But I do have some other concerns on this bill. You stated that there is no other process for this. In fact, in the duties of the Commissioner of Corrections and also with the sheriffs, they have the authority to early release somebody from incarceration. They have that authority already. If somebody's behaving good, they can do that. And if they're on probation, if the person on probation has a right to petition for release. And if the probation agent believes it's good, it should be no problem in court to do that. We have laws on the books now that take care of this issue. I don't know why we need to bring up a new one unless the Commissioner of Correction doesn't want to be able to do his duties. I know they're changing the way of, looking at changing the way of pardons to go from a unanimous to just 2/3 vote. And there again, it's reducing the responsibilities of the people involved that have that distinct authority. So the commissioner has the authority to release early now. The sheriffs also have that authority. When the COVID crisis hit, a number of them were released. Some released on furlough, and I believe there was a few that released and did not have to come back. They counted as their sentence served. So I'm glad it's being laid over so we can look at it longer, but like I say, I do have some concerns on this, especially for victims of crime. If the crime didn't have a victim, I'd be a little more receptive to this, but when there's actual victims, whether it's violent crime or victim of burglaries, because it affects those people greatly, I think I could accept it a little better. Thank you.
Representative Moller.
Thank you. I've taken a lot of notes here because there's quite a few things I want to address, and I think from both of the comments that were just made. First of all, regarding prosecutors' use of time, this isn't an either or. Prosecutors are still prosecuting crimes, and then will have the opportunity, if they want, because it is 100% discretionary, to do this. I would note that we've got some data from the other states that have enacted this, and comparing what our prison population is to those states, it would potentially be maybe even less than one case per month statewide. So this isn't using up a ton of resources or time. So just to be clear that this isn't either prosecute this murder that's happening now or go back in time and look at this. They're able to do both things. I also want to talk for a minute about victims. There's no denying that victims of crime, especially traumatic crime, can experience trauma and have lifelong consequences as a result of that crime. There is absolutely no question that that happens for many victims, and I don't want to suggest otherwise. But I will also tell you that not all victims are the same in what they think consequences should be. For many victims, they want to know why this happened to me. They want an apology, and they may want rehabilitation of the offender to know that that isn't going to happen again. And so I don't think we can just assume that every victim of a violent crime is going to be upset with this, and that also is why we have so much built into this bill in order to reach out to the victims to get their input before the prosecutor would even decide to move forward, because what they want is very important. Minnesota Coalition Against Sexual Assault, Violence Free Minnesota, represents victim advocates across the state, and this is domestic violence and sexual assault cases. They represent victims who have experienced horrible, traumatic events, and yet they support this bill. I also just want to talk to a minute about what the commissioner has the authority to do. And Representative Johnson, I appreciate our conversation we had about that. And I asked the department, and they do have a work release program where they can release people early, but it's under very limited circumstances. So that's different from what we're trying to do here. I think that I captured everything, but those were the points I wanted to address.
Thank you, Representative Moller. Representative Carroll.
Thank you. I'll be quick because I think Representative Moller addressed some of the things I was going to address. And speaking to the other side, having worked in the Hennepin County Attorney's Office, I can tell you that prosecutors and attorneys aren't sitting around looking for things to do. So there's a safeguard here that it's initiated at the prosecutor's discretion, only if the prosecutor wants to. And then also they have to take into account the impact on the victim. So some of those safeguards are already in this. So I think maybe you could take some comfort in knowing that prosecutors aren't going to be willy-nilly, reviewing everything. And I doubt there'd be a county attorney's office that'll set up a special division to review these cases. So I imagine it'll be an extraordinary circumstance.
Thank you. All right. Any further discussion to the bill? All right. Closing comments, Representative Moller.
Thank you, Madam Chair and members. I just want to tell you about 3 people for whom this, in another state, for whom this was used. Alwyn Smith. Alwyn became a pastor while incarcerated and now volunteers at his church to provide showers for the homeless, and he works as an employment specialist with a reentry services organization. Isaiah Love did an incredible amount of self-work while in prison, and with the support of community-based organizations that worked in collaboration with the prosecutor's office, Isaiah was released and is now a computer programmer. Caitlin Vaughn was one of the first women released under this program in California and was praised by the judge during her resentencing hearing for all the rehabilitative programming and substance abuse recovery work she has done while incarcerated. These are people, there serves no public safety interest to keep them incarcerated longer. This is a good bill, and I look forward to your support. Thank you.
All right. With that, the bill is laid over. Thank you, Representative Moller. Next up, Representative Frazier. All right. While Representative Frazier is walking up, I will move the House File 1083. Move House File 1083 before the committee. We don't have a fiscal note yet for this one, so we will lay it over after the DE. So that's why we're moving it in front of the committee, and then we will lay it over. Representative Frazier, so let's go ahead and move that DE. So I will move the DE1 amendment to House File 1083. All those in favor, please say aye. Aye. Opposed? The motion prevails. Representative Frazier, to your bill as amended.
Thank you, Madam Chair. And the amendment, what it did was, sorry, can folks hear me? All right, there we go. What the amendment did was it put the bill in a shape for it to actually carry out the intent of the bill. When we came through this process to work on this, what we know is we have a big issue with identity theft and mistaken identity right now going on just in society overall. And what we've seen in some situations when folks are charged or prosecuted for situations where it is a mistaken identity or someone has stolen their identity. Folks have had difficulty as they've gone through the process of trying to ensure that those things don't linger on and follow them through the rest of their life. So what this bill would do, it would require that when a case is dismissed for mistaken identity, or someone is charged or prosecuted for mistaken identity or stolen identity, it will require that those cases are automatically petitioned for an expungement. So the individual wouldn't have to petition for the expungement. It would be automatically sent through the process for an expungement, and therefore making it easier for the individual to move on and be put back in the position that they were in before the stolen identity happened. That is it. Pretty straightforward. This bill has been around for a while. It's gotten kind of quite far through the process in most cases, but hoping we can get it done this year.
Yeah, it's the year to get stuff done. Discussion to, we didn't have any testifiers signed up. Is there anyone from there's nobody in the room. Is there anyone from the public wishing to testify in this? I looked up and see the sergeant and our pages, wishing to testify on this bill. All right, discussion to the bill, members. Representative Johnson.
Chair Becker Finn, Representative Frazier. I don't know how you did it, but you got me to sign on to one of your bills.
Representative Frazier.
Yes, and Representative Johnson, I wanted to thank you for signing on to the bill. I think one of the things is, since I've gone through the process of working on this bill and research and having conversations, almost everyone that I talk to knows someone that has had their identity stolen, or gone through this burden. And so I think that's a big part of it. I think the data I looked at says 1 in 20 individuals has been impacted by it, but I think anecdotally, almost everyone knows someone that has been impacted by this.
Yep. All right. Closing comments, Representative Frazier.
It's a good bill. It's been in the works for a while. I think this is the year to get it done, and we can, give people an opportunity to kind of get back to their lives to the point prior to where they had their identity stolen.
All right. With that, House File 1083 as amended is laid over. Stay put. Representative Frazier, would you like to move House File 1084 be recommended to be placed on the general register?
That is my motion, Madam Chair.
All right. I understand you have an A2 amendment and an oral amendment. Which one would you like to do first?
Let's do the oral amendment first.
All right. So to your amendment, Representative Frazier.
So this oral amendment, only thing it does is there was some language that was stricken. I had some conversation with some advocates, and the concern was that it doesn't substantially change the bill. The concern was that the language that was stricken would not allow the bill to fully meet the intent. And the intent is to expunge and seal the records and vacate the records. And so we want to reinstate this language, and I will make the motion to reinstate pages 1, lines 9, or reinstate on page 1, lines 9 and 10, reinstate the stricken language. And I can,
Just looking to
Go ahead.
research to make sure we've got that right, Mr. Johnson.
Madam Chair, members, if it was written out, it would say page 1, lines 9 and 10, reinstate the stricken language.
All right, so that is Representative Frazier's motion.
that is the motion.
All right, any discussion to the motion? All right, all those in favor, please say aye. Aye. Opposed? Motion prevails. Thank you, Mr. Johnson. And now to the A2 amendment. Representative Frazier, would you like to move the A2 and then tell us what that one does?
I would like to move the A2, and I would like to lean on Mr. Johnson to, if he could, walk through the.
That's why he's here, I think. Representative or Mr. Johnson. he always shakes his head really hard when we accidentally do that. Mr. Johnson.
Madam Chair, members, Ben Johnson from House Research. The A2 amendment makes some changes that are related to the Department of Human Services. Very briefly, when there's an expungement order, it gets sent to a variety of people. That includes the Department of Human Services, because they have to look at people's criminal records for background checks, and they keep those old criminal background checks that they've done. And so if an expungement order is issued, it needs to also typically be sent to the Department of Human Services. This is essentially conforming language that Department of Human Services requested, just making it clear that when there is an expungement issued under this new process at following a pardon, that it will be sent to the Department of Human Services. On page 5, there's a new section, it's section 4, that talks about the method of the pardon extraordinary taking place. In essence, the pardon board would be issuing the pardon, then the district court would be issuing the order as though it were a regular pardon order, and then, a regular expungement order, and then that would get distributed to everybody, including the Department of Human Services.
All right. Any discussion to the A2 amendment? All those in favor, please say aye. Aye. Opposed? The motion prevails. The amendment is adopted. Representative Frazier, to your bill as amended.
Thank you, Madam Chair. This is another one about allowing individuals to move on after a period of time after they've been held accountable. I always say that accountability has its place, but there are times, and I believe at some point, you should have an opportunity to move on from that situation that you were in before. Right now, we have an individual has an ability to petition for a pardon. That is conducted by the Pardon Board, which consists of our Chief Justice of our Supreme Court, the Attorney General, and the Governor. However, once the individual actually receives that pardon, if they do, there's not a lot of pardons that are given. They only meet twice a year. I have the stats I could share with folks, but not many are given. But when once they receive that pardon, the issue is they receive the pardon, but the information still remains public. So it doesn't quite take care of or do what is intended to do. So what this bill would do would essentially allow for, once the pardon is put in place, the records would actually be expunged and sealed.
All right. I don't have any testifiers signed up. Is there anyone from the public wishing to testify on this bill? All right, not seeing any. We'll move on to member discussion. Any discussion to the bill? All right. Representative Frazier, closing comments.
I think it's a good bill. I think it's another one it's been in the works for a while, and looking forward to getting it done.
All right. Representative Frazier renews his motion to recommend House File 1084 as amended be placed on the general register. All those in favor, please say aye. Aye. Opposed? No. The motion prevails. All right. Representative Scott, let's talk about forfeiture. Everybody wake up.
Just gonna stay here tonight.
Representative Scott, would you like to move to recommend that House File 118 be placed on the general register?
That's my motion, Madam Chair.
All right. Please tell us about your bill.
Well, thank you. I just got my old file, and y'all will be glad to know I just crossed out last year's bill number and wrote in the new one. I'm saving paper. House File 118 is a technical fix to clarify how complaints in these forfeiture cases can be served. In 2021, Representative Moller and others worked really hard on some forfeiture reform legislation that contained parallel structures for both DWI and controlled substances. However, there were some differences in the two sections, including how complaints are served. In the DWI section of the 2021 bill, complainants were allowed to serve documents to the prosecutor by certified mail or by, as the language read in the bill, by means permitted by court rules. For controlled substances forfeitures, the 2021 language stated that complainants could serve the complaints by any means permitted by court rules. These differences were cause for confusion, so the courts brought this to the attention of the legislature. This bill seeks to align the two sections by making the language identical for both DWI and controlled substances forfeitures, allowing complaints to be served by certified mail or by any means allowed by the court. It also clarifies the rules for service depending on whether the forfeiture is challenged in the district court for those cases over $15,000 or in conciliation court for those under $15,000. And this language has the support of stakeholder groups. So I appreciate the bipartisan support, and hopefully we can get it done.
All right. Are there any members of the public wishing to testify on this bill? All right, not seeing any member discussion. Representative Moller.
Thanks, Madam Chair. Just wanted to thank you, Representative Scott, for bringing this bill, but just for all of the hard work you've done on this forfeiture issue over the years. I've enjoyed working with you on it and know you really care about this issue. So but glad you could bring this bill this year.
All right, any further discussion? Representative Scott, closing comments.
It's a good bill. It's needed. Support it, hopefully.
All right. Representative Scott renews the motion to recommend that House File 118 be placed on the general register. All those in favor, please say aye. Aye. Opposed? No. Oh, come on.
So cold.
Your own side. Wow. Okay.
You just woke up.
Thank you, everybody, for your diligence today. We got through a lot of bills. You should be proud of yourselves. With that, we are adjourned.